Good afternoon and welcome back to this teleconferencing session. Before the break, we have talked about the planning and organization of outpatient services and inpatient services. Now, in this particular session, we are going to have a panel discussion on mediation. I think if you remember that last time we covered some of the legal issues in the medical care practice, and we thought it will be appropriate that to have a panel discussion on the process of mediation, that how mediation can be brought, how it can be done. So we have with us Justice Madan B. Lokar this afternoon to deal with this topic. Now I will request Professor Krishna Dev Rao, who is the Director of School of Law, and also I have with me Professor Ilumna Malai. He is also from School of Law. So this is our panel for discussion on mediation. Now I will request Professor Krishna Dev Rao to just take over the proceedings.
It's a great pleasure to introduce and invite Justice Madan B. Lokar to Indira Gandhi National Open University and to this panel discussion on key features of mediation. Let me introduce Justice Madan B. Lokar and then we will come to this topic. Justice Madan B. Lokar is a sitting judge of the Delhi High Court and has a vast experience of almost more than 3 decades in civil, criminal, constitutional, revenue and service law. He was the editor of the ILR Delhi series for 15 years from 1983 to 1998. He was the Additional Solicitor General of India from July 1998 till the appointment as Additional Judge of the Delhi High Court in February 1999. Justice Madan Lokar is a very unique and a very dynamic person who is actively involved in the institutionalization of mediation in the Delhi courts. I welcome you, sir, to this panel discussion. Let me take a couple of minutes to explain about the concept of the mediation and its importance and significance in the Indian legal system. I think every day which is being discussed in India is the crisis. The major crisis which is faced by the justice delivery system in India is the pendency, the arrears, docket explosion leading to delay in dispensation of justice. So there was a critical introspection all over the world, including in India. How do we address these major problem of arrears and pendency, and how do we resolve the disputes amicably, establishing the relations between both the litigants and to restore the trust and respect and relationship between the litigants. That was the major challenge before the justice delivery systems all over the world. If you look at in India, India has a very long history of using the informal dispute resolution methods through the panchayats, and one of a very veteran, Mr. D.K. Sampath, who often used to say that the alternative dispute resolution method is known to India for a very long time. He said it's a traditional concept in our society and a time-honored method of deciding disputes. And in panchayats, one of the unique features is a third party whom both the parties trust and have a mutual confidence, and this person or a group of persons and a third parties unconnected with the conflict, they intervene and establishes and re-establishes communication and relation and pursues these parties to settle. Even though we have a critique about the traditional conventional panchayats where the dominant caste used to have an influence, but there's a need to democratize and to strengthen this community dispute resolution which is existing in India. In this context also, I would like to mention about John Wallis. Justice John Wallis in the Privy Council way back in 1934 also highlighted the decisions and the disputes resolution methods used by the panchayats in India. As Justice John Wallis in 1934 has said, it is in the panchayats easy to ascertain facts and avoid protracted litigation, and the informal settlement is there based both on legal and moral grounds. And a very eminent jurist, Roscoe Pound, has said, again way back in 1910, he was looking at the major crisis in the American legal system, and he said American legal system also need to explore the alternatives. So this is the scenario wherein all over the world, including in India, there is a major crisis and a challenge how to resolve the disputes amicably. In this context, we thought we will hold a panel discussion to looking at the various the structure, the process, the advantages of the mediation. Before I hand over to Justice Madan Lokur, the main panelist of this discussion, I request my colleague Professor Elumalai to explain what are the recent initiatives taken in India which is a way towards institutionalizing the alternative dispute resolution methods in India in general and mediation in particular. Over to Professor Elumalai.
Thank you, Professor Rao, and I also join Professor Rao in welcoming Justice Madan Lokur Sahib, who has spared his valuable Sunday to come over all the way here, because judges rarely get any time for all those things and all. Now, coming back to this subject, now see, it has become a concern of all, including the legislature, judiciary and the executive, even the common man, about the matters pending before the court of law. And in this background only, although across the world this settlement through mediation has obtained the legal status much before India has taken place in India. In that way, based on the global experience, also taking other factors into consideration, in India, this Indian Civil Procedure Code was amended in the year 2002, which particularly the sections 89 of the Civil Procedure Code was incorporated in the statute book in the year 2002, and it cast an affirmative responsibility on the courts to seek alternative resolution mechanism such as arbitration, lok adalats and mediation. As per this section, Section 18 of the CPC enunciate that if there is any chance of a settlement of a dispute amicably in a matter, the presiding officer of the court may refer the matter for alternate dispute resolution. Another interesting feature of the Section 89 is, it says that, or it may suggest, even if the referral to the mediation is proper, even when neither of the parties agreed to settle the dispute, but if the parties are honestly willing to explore the possibilities of settlement through mediation, and if the presiding officer finds appropriate and he feels that parties are not interested but they have the honest willingness to settle that, even then the matter can be referred to the mediation for mediation center. And this is about things. Then in the recent case, in a judgment of the Supreme Court in the Salem Bar Association Union of India, requested a committee to prepare draft model rules of alternate dispute resolution and draft rules for mediation under Section 89(2) of the 89 subclass 2D of the Code of Civil Procedure Code. In accordance with the request of the Supreme Court, draft rules for pursuant to this judgment, the committee has prepared the set of rules. It has consist of two type of rules. Number one, consisting of the procedure to be followed by the parties and the courts in the matter of choosing the particular method of alternate dispute resolution mechanism, and the second set of rules consist of draft rules for mediation under Section 89(2) of the Code of Civil Procedure. Now I don't want to make you people to wait any longer because our main panel is there. I will request the honorable panelists to kindly make a presentation on this subject matter.
Over to Justice Madan Lokur.
Thank you very much, first of all, for letting me participate over here. My idea is, for the present, if it's acceptable to you, is to just to give a broad, framework about what is mediation and, how we've been going about it in Delhi, and, make people aware of mediation. Now, the first question that obviously arises is, what is mediation? It's there, of course, in the statute books, but it's not been defined in Section 89 of the CPC, nor has it been defined anywhere else. So the question is, what is mediation? Now, mediation is actually a voluntary process, of dispute resolution, where the mediation process itself is conducted by an independent person. There are two litigating parties, their advocates may or may not be present, but there is an independent person who is the mediator and who will help the parties resolve their dispute. His job is really that of a facilitator. He is not there as a judge, he is not there as an adjudicator, he is not there as a person who is going to decide what is right or what is wrong. He is going to facilitate the parties in arriving at an amicable settlement which is acceptable to both the parties. Now in Delhi we started mediation, institutionalized mediation on the 1st of August 2005. So it's been about 3 years since then. And the experiment that we started in Delhi, which was in the district courts, first in the Tisari courts, and then it was a couple of months later in the Karkaduma courts. We call it court integrated judicial mediation, which is to say that it is a part of the court structure. We have judicial officers who are there as mediators. Over these last 3 years, we've expanded the base of mediators, and we no longer have only judicial officers as mediators. We also have lawyers who've been trained in mediation. They are also mediators. The reason why this system was taken for Delhi is that the committee that was set up by the then Chief Justice of India, Justice R.C. Lahoti, that committee was of the view that this is something which is best suited to the Indian ethos and best suited to the Indian conditions. So therefore it started off as a sort of a pilot project, and fortunately that pilot project has succeeded, and we've gone a long way from 1st of August 2005. The second question that would arise is what is the mediation process? What actually happens in a mediation? First, like I had mentioned earlier, you would have the litigants, you would have the lawyers. It's not mandatory for the lawyers to be there, but if the litigants want them to be there, they're of course welcome. And then you have the mediator. The mediator will introduce the mediation process to the litigants so that they understand what mediation is all about, what is his job, what is the job of the parties. He will also inform them that this is a completely confidential process and that he has absolutely no interest in the disputes. In case he does have an interest, then of course one of the parties can object. And confidentiality is an extremely important aspect of it, so that the parties can come out with whatever they want to say. Otherwise, if it's not a confidential process, then maybe the mediator may not get to know the truth of the dispute between the parties. So it begins with an introduction. It's a short introduction, maybe 5 minutes or something like that. Then there is a joint session where each party will explain his side of the story. So the plaintiff will say that this is what has happened and this is why I have made a claim. The defendant will say that, well, according to me this is what has happened and this is why I am resisting the claim. So in that joint session, the broad facts are understood. The mediator gets an idea of what the dispute is all about. And of course, if during the course of discussion, if it appears that the parties can settle or can agree on some kind of a formula, then of course the settlement is arrived at. But very often what happens, and this happens I think particularly in family matters, matrimonial disputes, sometimes in some commercial disputes, where the parties want to share some private or confidential information to the they want to give that information to the mediator, but they don't want the other side to know that information. So they have something called a private session, where the one party will walk out, the other party will explain the his side of the story, some things which he does not perhaps want to tell for whatever reason in the presence of the other party, and then the other party will then come and give his side of the story. The mediator will not say in the private session that this is what the other party had told me. Otherwise the element of confidentiality goes. So yes, So there is this private session if it is necessary. It's not there in every case, but in a large number of cases, particularly matrimonial cases, there is a private session. After the private session is over, there could be more than one private session. Then again, there would be a joint session, and the parties would, or the mediator would assist the parties in arriving at some kind of a settlement. By and large, our experience has been that, well over 60% of the cases have been settled through this process of mediation, which means that there are about, say, 35% of the cases that have not succeeded. So it is not that in every case, the mediation process is successful, but there is a very large percentage. The advantage of this, of course, is that it can be done across the table. Some of the other advantages I will come.
Informal manner.
Yes, in an informal manner. There is no formality in the sense that the mediator does not wear a black coat and bands and that sort of thing. It is completely informal. The parties are put at ease. If temperatures run high, the mediator breaks the session and says, all right, we'll meet after 5-10 minutes. Sometimes they go out and have a cup of coffee or a cup of tea, and then they come back. So the entire thing is informal. Otherwise, there is no difference between that and a court.
Atmosphere is made very cordial.
Yes, it's made very cordial. People are put at ease, and that's one of the things that the mediator has to do at the time of introducing mediation to the parties. What is the role of a mediator? You see, like I had said earlier, the mediator is not a judge, in the sense that he doesn't decide that you are right and you are wrong. That's not his business. He's not an adjudicator, he's not an arbitrator. He doesn't say that, well, this is what my opinion is, or I think that this is the right way to settle it, or that what offer he has given is the correct offer, or it's the best offer. That's not his job. He is really a facilitator. So when one party gives an offer, that offer will be discussed, and perhaps the mediator might suggest various options to that offer, so that the other party can also apply its mind and see whether that offer is good enough or not. So he is essentially a facilitator, and this is, I think, crucial, to the mediation process.
Sir, one small doubt, sir. Can there be more than one mediator? Have you ever in Delhi whether experienced of having more than one mediator?
Yeah, you see, what has happened is that initially, soon after the training is over, and the mediator is still in the process of finding his feet, what we do is we have somebody sitting along with him, an experienced mediator sitting along with him. So in those cases, we have 2 mediators. But when that newly trained mediator is able to find his feet, then he does it by himself. I cannot recall many cases. Maybe there might be 1 or 2 cases maximum where you have 2 mediators, except in the initial stages of soon after training. But otherwise, it's only one person who's the mediator. And you see, one of the beauties of this process is that because the mediator is not a person who decides, it's the parties who decide.
Yes,
The part,
an umpire.
He's like an umpire, an umpire or a referee, or
Seal of approval.
So it's the parties who decide, because the parties know what is good for them. Yes. I may want to have a business relationship with a particular person. I don't mind losing some money initially, but I want that business relationship to continue. So I decide that, well, it's in my interest. The other party may have some other interest in the matter. In family disputes, matrimonial disputes, the husband and wife may have some interests. Mediator cannot tell them that this is the best for you. Perhaps it may not be in their interest. So it's the parties who really decide what is good for them, and therefore it's a sort of a win-win situation for both the parties, because they both go away happy. I got what I wanted, he got what he wanted, so both of us are happy. So this is, I think, one of the plus points about mediation, unlike in a court case where one party will lose.
Exactly.
right? And the other party will then file an appeal or, take it up to a higher court. Here, both the parties have agreed to a settlement, so therefore there's no question of an appeal or a revision or, any further proceedings. Sometimes I'm asked, what does it take to become a mediator? Now, it has been agreed by the committee set up by the Chief Justice of India that a course of 40 hours, a training course of 40 hours is essential. You just can't get up one morning and say, well, I want to be a mediator. You need training. You need to be educated about the nuances of mediation, the art, the technique, the science of mediation. So we conduct a 40-hour program where the parties, where the trainees, are given the broad base of mediation. We in Delhi have prepared a curriculum. We have a course structure.
Sir, some additional information I would like to have from you.
Yes.
In addition to undergoing the 40 hours courses,
yes.
is there any specific qualifications prescribed for becoming a member of the, becoming
a mediator? Yes. You see, under the rules which you had mentioned as a result of that Salem Advocate Bar Association, the requirement is that you must have had 10 years of practice as a lawyer. So we don't take persons who are fresh out of
it's only liar. It's only liar who can be the
yes. You see, because at the present moment, like I said, it's a court integrated mediation.
Okay.
So it is cases which are pending in a court, which are referred for mediation. But otherwise, like you have in the panchayat system,
he was
for example,
mentioning about the panchayat.
So there, a person need not be a lawyer. For example, if you have a construction dispute between a contractor and somebody who's asked for a construction, well, they can refer the dispute to an engineer. So that engineer need not necessarily be a lawyer, because that sort of a dispute is outside the court system. So at the present moment, we are looking at within the court system, because of the problems that Professor Rao had mentioned. We have a large backlog of cases and so on. So we are trying to reduce that backlog through the process of mediation. Then we also insist, that just because you've done the 40 hours training, it doesn't mean that you're good enough to be a mediator. We would like you to do some 10 mediations, successful mediations, so that we know that you've understood it. And maybe sometimes the trainee finds that he does not have the aptitude for this. But we request the person to do 10 mediations, 10 successful mediations, before we can recognize him as a mediator. This applies to judicial officers. This applies to lawyers as well. And what we have found, coming back to your earlier question, what we have found that sometimes if the training is inadequate, it can be dangerous also. For example, you may have in a matrimonial dispute where the parties are, at a short fuse. If the person is not trained, the relationship between the parties can be irreparably damaged.
Instead of bringing a compromise, he may widen
he may widen the differences.
Quite possible.
Similarly, in matters of custody, it might just explode if the person doesn't have the proper training. So the mediator should know not only how to proceed, but when to stop also, so that no damage is done. So these are a few important things that we are looking for, in a person becoming a mediator. As a general rule, what are the qualities of a mediator? He must be impartial. He cannot, say that, well, take sides. That becomes a decision-making process. You're right, so therefore I agree with you. So he has to be completely impartial. So therefore, in the beginning, he has to explain that he does not have any interest in the dispute or in any of the parties. Patience, I think that's extremely important. He must have the patience to listen to the parties, because sometimes they may say things which are not really relevant. So he must have that patience. He must have the imagination to come out with solutions. You know, one party gives one solution. Well, he should be imaginative enough to say that, well, you can modify the solution in this particular manner. You know, would you like to look at it from this point of view? Or would you like to
various options.
generating various options? Yes. You know, that's important.
Best possible and worst possible, perhaps.
Yes. The best alternative.
Alternative,
you
sorry.
know,
Best alternative.
The best alternative, the worst alternative.
Mm.
You know, what do you think is in your interest?
Yes.
You know, do you think this will damage you, and so on. So this is something which I think it's a quality, you know, which has to be
Maybe he can
developed.
explain pros and cons of various alternatives.
Yes. And you know, also look at it from the point of view of whether it's within the law or not within the law. You know, so these are certain things. Good listening skills.
Yeah, that's
You know,
active listening is very important.
Active
because
listening is
unless you listen,
yes.
then it will be difficult. First
That's right,
you have to
yeah.
spend a lot of time to gain a confidence of both the parties. After listening and slowly
Yeah.
persuading them.
Yeah. You see, because a litigant wants to say why
Yes.
he's in this problem.
Yes, in the problem.
You know, you can't tell him that, well, I don't want to listen to you. It's like, you know, a doctor and a patient. If the patient says, I'm unwell, the doctor is going to ask him, what's wrong with you?
Yeah.
You know, he's not going to say, well, I don't want to listen to you, and I don't want to know whether you have a headache or a stomachache. I'll find out. You know, so these good listening skills are essential. Active listening is essential. He must have the ability to secure the confidence of the disputants.
Yes.
You know, again, like a doctor.
Yes.
I will go to a doctor in whom I have faith. I'm not going to go to any quack.
Yes.
Right? So
Here also both parties should have faith in that.
they should have faith, you know,
That's very important.
and that's where the introduction part comes in.
Yeah.
Skills and techniques of negotiation. You know,
That's another.
it may happen that one party says, well, I'm not going to agree to anything. You know, then he should be in a position to negotiate and tell him
the
that,
other
well,
party. That's a convincing power.
yeah, that, you know, don't close all the doors. You know, at least leave one window open. You know, and then we'll see if he can open the door after that. If he has expertise in his area of mediation, it helps. You know, I mean, for example, if a lawyer has done a large number of matrimonial cases, he may have come across a similar case of this nature. If he's done a lot of cases pertaining to, say, motor accidents, you know, so that expertise would help, but it's not absolutely essential. He need not have a mediator need not have the skills of a lawyer. You know, he's not going to argue a case, right? So he need not have the skills of a lawyer. He need not have the skill to decide what is right and wrong. I mean, that's the job of a judge, right? He need not necessarily have expertise in law, like I had mentioned about you know, a building contract. An engineer can do the job. He need not be a lawyer. So it depends on the nature of the dispute, you know, how the parties want to go about settling it, and so on. Advantages of a skilled mediator. This is also extremely important. A skilled mediator, I had mentioned earlier, he's in a better position to resolve disputes rather than an unskilled one. Unskilled one may create a problem. You would have strategic barriers that are sometimes created. You know, I don't want to discuss this, you know, or I'm going out, or this man is being unreasonable. How do you overcome that? You know, so these are issues which come with training, which come with experience. And then one of the advantages is that he can explore options that have not previously been explored. You know, maybe the parties have not thought about it, but during the course of discussion, you know, something gets generated, and he says, well, how about looking at that? You know, it's not that the mediation is over in one session. It may go on for 2, 3, 4, 5 sessions. So, all right, one option has been generated today. Would you like to think about it? Fine. You know, come back after a week, come back after 4 days, and then we look at that option. Again, it encourages direct negotiation and communication between the parties. Very often, litigants feel that if I talk to the other party, it means that my case is weak. That's not correct, right? So, but they don't want to talk to the other party because they think that the other party may have this view. But here in a mediation, you know, both the parties are talking, you know, and they're not. It's not a question of who's going to talk first. It's a question of arriving at some kind of a settlement. So it doesn't matter, whether you think you have a bad case or the other party thinks you have a bad case. It's a question of how you want to settle the dispute. It's far cheaper than litigation. In the Delhi Mediation Center that we have in Tisari and Karkuduma, we don't charge anything, it's free. So there are no litigation costs. On the other hand,
the parties are entitled to get the refund of the court fee if the mediation becomes successful.
And that's right. Yeah, Section 16 of the Court Fees Act was amended along with the CPC. So if the parties settle their dispute, you get a refund of court fees. So it's not that you spend money, but you earn money, or at least you get back.
But sir, what is the mechanism to channelize all these cases before these mediation centers? How do you select?
You see, it depends upon the judge. Now, what we are doing is we are, apart from this mediation training, we are training the judges, to identify cases which, can be settled. Which have an element of settlement, as Section 89 says.
Yes.
So that training is also given, to these referral judges, so that you don't refer a murder case, for example, for mediation. So that kind of training is given to the judges, and the matter is discussed with the lawyers, with the parties, and if one party says no, whatever happens, I'm not going to settle it, well, then you don't settle it, don't send it for mediation. The results are faster. There's a time limit. Under the rules, you have to say yes or no within 90 days. We try and stick to a 60-day deadline, but sometimes it goes up to 90 days, if it's a very hotly contested case, matrimonial dispute, or there are a lot of stakes involved. Very rarely. It goes beyond 90 days, if the mediator feels and the parties feel that, we are pretty close to a settlement. It doesn't matter if it exceeds that 90-day limit. But that's happened, I think, maybe in just 2, 3, 4, 5 cases, very few cases. But most cases settle within 1 or 2 sessions. I think the maximum that has gone on is perhaps 5 sessions. It may be spread over a period of time because of the intricacies involved, but it's certainly much faster than litigation. Then it's an interest-based procedure rather than a rights-based procedure. I'm not asserting a right. I'm looking at my interest as a litigant. So it's in my interest to settle, and it's in my interest to settle on these terms. If it's in your interest to settle also on certain terms which are similar to mine, then we can, settle the matter. Whereas in a court, I'm asserting a right, that it is my right to get money from you as damages for breach of contract. Right? So I'm asserting a right, not so in a mediation. So there is this qualitative difference between litigation and mediation. Emotions and feelings are preserved, particularly in matrimonial matters. There's no stress, there's no strain between the parties. Commercial disputes, parties are more interested in going on with their relationship rather than breaking it. More options are available to parties. In a court litigation, this is the dispute. Either you're right or you're wrong. But in a mediation, you can look at a whole range of issues. In a matrimonial case, for example, there would be, if it's a divorce, custody of children. If it's, it could be maintenance. Whereas if you go to a court, if you are arguing a case of divorce, you have to argue the case of divorce. The custody case will be heard by somebody else. Maintenance issue will be heard by somebody else. But here, the parties can sit together and say, all right, we want to settle all our disputes. We've had instances, where 28 cases have been settled within the family, because they said, all right, if you're going to settle it, let's settle everything. There's been one case where 133 issues, were settled with relation to a bank. This 28 cases was a family dispute. So, you look beyond the court structure. The dispute is finally resolved. I mentioned this earlier, no appeal, no revision. Multiple disputes, can be resolved. Particularly matrimonial or family disputes. Most of them are multiple. And relaxed and informal procedure. You know, I mean, no formalities. You know.
Because both the parties are involved in settling up the dispute, so they get that confidence.
Yeah,
and,
yeah. You know, you sit across the table.
Yes.
You don't have to stand and argue.
Exactly.
There's no judge wearing a coat and bands and all that. And you want to bring your cup of tea in, fine, bring it. You know, there's nothing wrong with it. You can't do that in a court.
Yeah.
But in a mediation, it's completely informal. Well, we've had this pilot project now in Delhi for 3 years
Yes.
under the auspices of the Supreme Court, and the success rate is well over 60%. I would put it at about 65% or so in Tisazari and Karkaduma put together. What we have found is that proper management is absolutely essential. You know, it's like again coming back to the example of doctors. You have a hospital. You can't have a hospital without a manager. You know, otherwise there'll be utter chaos. So you need somebody to manage the mediation center. You know, we call him a coordinator or we call him a judge in charge, but you need somebody there. The coordination mechanism, like I said, is extremely necessary for administrative issues, referral issues. You know, keeping a track, supposing all bogus cases are being sent by a particular judge for mediation, then that coordinator can talk to the judge and say that, listen, why are you sending these kind of cases? You know, or if a mediator misconducts himself and every time he says no settlement, it's the job of that coordinator or that manager. You know, and I think what we have achieved over the last 3 years is that lawyers, particularly in the district courts and now in the High Court as well, you know, are having faith in this process. There was a problem initially. ADR, that's alternative dispute resolution, was thought of as alarming drop in revenue. You know, but now lawyers are accepting it. Not only are they mediators, but they are also participating as advocates.
That's a really good trend.
That's a really good trend. It's I think very positive. You know, because after all, in a litigation, what are you looking for? You're looking for a solution. Now, if you get a peaceful solution, that's that much better.
Faster.
Yeah, faster, cheaper, and peaceful. You know, that's what you're looking for in a ordered society.
And you're also party into the decision making.
Yes. You know. So these are the advantages. Well, our future plans are, of course, to make people aware of mediation as an viable or as an available alternative. To encourage litigants to resort to mediation and to have an efficient justice delivery system, and to make it a reality through ADR and court management.
Sir, I would like to have a couple of clarifications which are academic in interest.
Yeah.
Number one, whether the time spent in mediation process qualifies for the condonation of the delay under Section 5 of the Indian Limitation Act, number one. Number two, somewhere I read, the referral of the matter to the mediation center shall not automatically stay the legal proceeding before the court of law.
Yes.
I feel some contradiction is there.
Yeah.
Can you kindly throw some light on these two aspects?
Yeah.
Number
You see,
one, condonation of the delay.
Yeah, condonation of delay. You know, if party is going for mediation, it will not, you know, condone any delay, right?
That means party have to go to the mediation at their own thing, is it not, sir? Because
yes.
Suppose if they fail to succeed, ultimately they have to go before the court of law.
Yes.
Then this time of 60 days, whatever it is, it's likely to affect the limitation period.
No, you see, this this period of 60 days or this period of 90 days is during the course of the litigation.
Okay.
Right. So while the litigation is going on, there is a sort of a stop for 60 days.
Okay.
30 days, 90 days, where the parties try and settle the dispute. So if an order has been passed earlier which somebody wants to challenge, of course they can challenge it, you know, without prejudice to the discussions that are going on. But the question of condoning any delay, you know, will not arise because that litigation is still continuing. But if before the suit is filed or before the litigation is filed and the parties decide to go in for mediation,
that's it.
That's not a court integrated mediation, but that's just a mediation between two parties who want to have a settlement. That will not, you know, I mean that period will not save the delay. Right? And on the second point, you see, when the parties say that yes, we are going in for a settlement, it is expected, and this I have not heard anything to the contrary, that until that mediation process is over one way or the other, the parties will not change their position.
Stand.
Yeah. So if a party says that yes, I'm prepared to go in for mediation, the other party says yes, well, it is understood that you will not, act to the detriment of the other party.
That's it.
If the mediation fails, fine, you come back to the court.
That's it.
That's how it works.
So the major challenge before the mediator is how to gain confidence and trust.
Yes.
And to maintain that trust throughout the mediation process. How do you think, what are the skills which are required? How a mediator can maintain that trust?
Yeah, you see, I think this issue of impartiality is extremely important.
Yes.
Which the mediator must bring home to the parties right in the beginning.
Right.
That I'm impartial, I have no interest in the dispute.
Yes.
I have no interest in any of the parties.
Yes.
It's like when you go to a court of law, you must have faith in the judge that he is going to decide according to law, and that he has no interest in the dispute of the parties. If the judge finds that, well, he knows one of the parties, he will himself say, well, I don't want to hear it, because if I hear it, then there will be an allegation that he's favoring one of the parties. But sometimes it happens that the judge may have dealt with the case maybe 15 years ago or 20 years ago when he was a lawyer or something, may not remember it. And if the parties remember it, they will tell the judge, and the judge will withdraw from the case. So a mediator will tell the parties that, listen, if you have anything to tell me, which will prevent me from going ahead with the mediation, please do so. Then you can always get another mediator.
Mediation as an experiment is being used even in the criminal justice, settlement of the criminal justice issues, particularly the victim offender mediation, which is emerging in various parts of the world. And keeping in view of the Indian context, the introducing the plea bargaining and compounding of offense already is there existing. How do you think the mediation can look at in the bringing both the victim and offender mediation? There are examples of truth reconciliation.
Even 138 of the Negotiable Instrument Act, although criminal thing is involved in that, but even then that may qualify for settlement through mediation and all.
So how do you think, keeping in view of this, even the criminal justice, I know not the serious important cases as you said, murder and others, but how do we use for even the resolving of the criminal justice?
You see, there are certain cases which have a civil law element. 138 is a good example. The bouncing of a check.
Checks.
So those can go in for mediation even though it's a criminal offense, right? It's compoundable.
Yes.
In matrimonial disputes, you would have a demand for dowry, for example. All right. You may have an application for maintenance under Section 125 of the CRP. Okay, so these are essentially criminal proceedings, but they are said to be criminal proceedings, but essentially they are civil proceedings. So these can be referred to mediation and can be resolved through mediation. But then you have plea bargaining, which is victim and accused related. That would be, I think, outside the scope of mediation, but the broad principles of mediation would be more or less the same for plea bargaining. If I was to introduce plea bargaining, I would perhaps do it in the same manner in which mediation has been introduced in Delhi. So plea bargaining can go ahead from there.
Thank you very much for your encouraging discussion and explaining about the key features of the mediation. And the Indira Gandhi National Open University, as a major leader in the open distance learning in India and all over the world, would like to take this forward and developing into a professional academic curriculum in the mediation. I think we will work towards that. And as you have rightly pointed out, the success of the mediation or the alternative dispute resolution methods much has to do with the belief, faith and wisdom of the judges, legislature and the people. In fact, the encouraging example of the institutionalization initiative in Delhi, which is a court-annexed mediation, which Justice Madan Lokur has shared with us, which was able to settle more than 60-65% of the disputes. And therefore, we could see that mediation in the initial days was considered as an alternative to litigation. But now with the successful experiment of the use of the mediation in various parts of India, including Delhi, we can clearly say that it's no longer an alternative. It has already been institutionalized as a normative part of the court system. So thank you very much if you have any questions, we could interact later. And this is a part of this, we wanted to create a major awareness and knowledge during in the paralegal program, where we have the informal dispute resolution, and community dispute resolution is a major key for creating a cadre of community people to resolve the disputes. Thank you very much.
Yeah, thank you.